Good evening. The webinar will start in 2 minutes. Good evening. Just to verify, you guys are seeing a BACP Entrepreneur Certificate program on the screen, correct? Thank you for those who responded in the chat. So this webinar offers closed captioning. To enable closed captioning, please click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the Chicago Department of Business Affairs and Consumer Protection webinar. Please note that any website or email that I mentioned will be posted in the chat box. For those seeking business licensing assistance, you can visit the Small Business Center at City Hall or call 312-74-GO-BIS, which is 6249. Also, business licenses can be applied for or renewed online by visiting chicago.gov/business licensing. The BACP Entrepreneur Certificate Program now has a new portal, and getting your certificate is as easy as 1, 2, 3. You can see the slide on your screen. You can do so by registering for the BACP Entrepreneur Certificate Program, attend 6 free BACP webinars from the listed categories, and receive credit after each one, and then graduate from the program and receive your certificate. Today's webinar will count as an elective. It is part of the certificate program. Graduating from the BACP Entrepreneur Certificate Program makes you eligible to apply for CIBC Bank USA's Entrepreneur Loan Program. For full program details, you can visit chicago.gov/BACP certificate. For a webinar calendar for future webinars, you can visit chicago.gov/BACP webinars. If you're already a part of the program, your account will automatically reflect the credit for joining this webinar within 24 hours. This webinar is being recorded, and the recording will be available at youtube.com/ChicagoBACP. I will post all of the information I've mentioned in the chat box. We encourage attendees to ask questions. Please utilize the chat box to send your questions. There will be a Q&A session at the end of the presentation. Please note that the views, information, and opinions expressed during this webinar are solely those of the presenter and do not necessarily represent the official policy or position of the Department of Business Affairs and Consumer Protection or the City of Chicago. Today's webinar is going to be an overview of Chicago's paid leave and paid sick and safe leave ordinance, as well as the Cook County paid leave ordinance. Your presenters this evening will be Miguel Campos, which is me, I am the Assistant Director of the Office of Labor Standards. And joining us from the Cook County Department of Human Rights and Ethics is their counsel, Tamiya Wright. So on your screen now, you should see Chicago's paid leave and paid sick leave ordinance overview. So we'll start with a quick outline of today's webinar. So the Chicago Office of Labor Standards will have a presentation presented by myself, Miguel Campos. We will go over an overview of OLS, the paid leave and paid sick and safe leave ordinance, key terms including accrual and usage, carryover and payout, notice and documentation, OLS required posting, employer policies, private right of action, the city's rules and outreach efforts, how an investigation occurs, and then at the end, a question and answer session. The Cook County Commission on Human Rights, that presentation will be by Tamiya Wright. She will go over the mission of the commission, the Cook County Paid Leave Ordinance, when it's applicable, employee rights, employer responsibilities, their complaint process, enforcement and penalties, and then finally she'll cover the differences between the Cook County and Chicago ordinances. And again, there will be a FAQ session at the end of today's webinar. You can either type your questions into the chat function, or there is a question and answer functionality within Zoom. So this is an overview of the Office of Labor Standards. The office is dedicated to promoting and enforcing Chicago's labor laws. We seek to engage communities and protect workers through a strong investigation and enforcement regime. We process complaints, we conduct investigations, we mediate disputes, we direct settlement proceedings, issue violations, and if necessary, we seek licensure discipline against employers. So we are here today to discuss the paid leave and paid sick and safe leave ordinance. On November 9th, the Chicago City Council passed the Chicago Paid Leave and Paid Sick and Safe Leave Ordinance. On December 7th, the Chicago City Council of Workforce Development passed an amendment to the ordinance, and then that amendment passed on December 13th of 2023. With the December 13th vote, the implementation of the ordinance is delayed until July 1st of 2024. So these are key terms with regards to the city's ordinance. So the ordinance guarantees up to 5 days of paid time off and 5 days of paid sick leave for all workers working within the geographical boundaries of Chicago. The covered employees definition is any individual who works at least 80 hours in a 120-day period, again, within the geographic boundaries of the city. A covered employee, again, we just covered, is any individual who works 80 hours within a 120-day period. An employee means an individual that performs work for an employer in the capacity of an employee. This is distinguished from a contractor, and this is determined pursuant to IRS guidelines. To qualify as an employer signifies a person who gainfully employs at least one employee in the capacity of employee and not as an independent contractor. Paid leave means time that is provided by an employer and can be used for any reason and is not paid sick leave. Paid sick leave means time that is provided by an employer and can be used to recover from illness, take care of a family member, address domestic violence and public health emergencies. So under the city's ordinance, this is how time is accrued and used. So paid leave, employees will earn 1 hour of paid leave for every 35 hours worked, up to 40 hours or 5 days in a 12-month period. Paid leave, once again, can be used for any reason, but requests to be used the time can be denied by an employer. An covered employee can request to use the paid leave that they've accrued 90 days after July 1st or after start of their employment, whichever date is later. And then we have a minimum usage increment that's not to exceed 4 hours with regards to paid leave. Sick leave is earned at the same rate, so 1 hour of paid sick leave for every 35 hours worked, again, with a maximum of 40 hours or 5 days in a 12-month period. Sick leave can be used to recover from illness, take care of a family member, address domestic violence, or any public health emergency. Sick leave, unlike paid leave, can be used 30 days after July 1st or after the start of employment, whichever is later. And then the minimum usage increment for sick leave is 2 hours. There are carryover and payout provisions within the city ordinance. So for carryover, you can carry over up to 16 hours or 2 days of paid leave if you're earning it as you go along. In other words, if you accrue. If your paid leave is front-loaded at the beginning of a calendar or fiscal year or commencement of employment, then there is no carryover provision. Paid sick leave, there's a carryover of up to 80 hours or 10 days, and this is whether the time is front-loaded or accrued. For the payout provision, payout is never required for paid sick leave. It is, however, required for paid leave. If you work for a large employer, which we are defining as an employer with 101 or more employees, then any unused paid leave upon separation of employment must be paid out. There is a payout of 2 days or 16 hours for a medium employer, which is defined as an employer that has between 51 and 100 employees until July 1st of 2025. After that July 1st date, it's required for all paid leave. So not just the 2 days, but it could be a higher amount. And it is not required at all at any time for a small employer, which we are defining as someone who employs between 1 to 50 people. Please note, and then this is a question we've gotten a lot already, at no time would you be required to pay out an additional amount than what is mandated by the ordinance. So, I went backwards, apologies. So notice and documentation. So paid leave, I mentioned at the beginning that an employer may establish pre-approval policies to ensure their continuity of business operations. Paid leave, if an employee uses paid leave, an employer cannot require documentation. Again, this is leave that can be used for any purpose of the employee's desire. And again, there's a minimum usage increment that is not to exceed 4 hours. For sick leave, an employer can require up to 7 days of notice if the usage is foreseeable or as soon as an employee becomes aware of the need for leave. Documentation for the usage of sick leave can only be requested after an employee uses paid sick leave for 3 consecutive workdays. And again, as a reminder, there is a minimum usage increment that is not to exceed 2 hours. Employers must post this informational poster at their place of business if applicable. It has to be provided to covered employees on an annual basis, and it will be updated by the city, the Office of Labor Standards, every July 1st. So these are proposals of what the new notices will look like once the law or ordinance goes into effect on July 1st of 2024. One notice contains information on minimum wage, wage theft, human trafficking, and then the bottom portion contains information on how someone can file a complaint or obtain additional resources and contact information for the office. The second posting has information on the paid leave that we've just covered, the paid sick and safe leave that we just covered, employer policies, including payout of upon termination of employment. And again, similar to the first notice, contains information on how an individual can file a complaint, and then where someone can seek additional resources and contact information. These forms will be available on the OLS website in simplified Chinese, English, Korean, Polish, Spanish, and Tagalog. And then if you are a covered employee, you can request additional languages from our office if needed. I mentioned employer policies. So the ordinance mandates that there's written notification of available leave. So this written notification is to be provided when wages are paid. This includes accrued leave earned since the last notification, leave which was used since the last notification, if any, and then available leave to be used in the future. This written notification can be provided via reasonable systems. For example, on a pay stub, an online system where employees can access their own information would meet the requirements of this provision or have a separate written notice. For paid time off policies, if you do have a paid time off policy, you are to provide it to covered employees. You are to give a covered employee the paid time off policy once they begin employment or within any 5 days within 5 days before any change occurs to an existing policy. So if you're going to change the number of days or how someone calls in that policy, you are to give the covered employee a copy of it 5 days prior to those changes going into effect. Your policy should include the accrual rates and periods, how someone accrues time. For example, is the time front-loaded, defining your fiscal year, and then if there are any notification requirements. So how is time requested? Are there pre-approval methods? Are you only allowing 50% of your staff to be off for Christmas, for example? If someone wants to call in sick, is there a procedure to do so? Do they have to send an email to their manager? Do they have to make a phone call? Do they have to notify ahead of time? So whatever your notification requirements are, they must be written and given to the covered employee. And then at the bottom of the screen, you see that the paid time off policy is to be provided in the primary language of a covered employee. There is a private right of action component to the city's ordinance. To the paid leave components for paid leave are delayed until July 1st of 2025. So this is July of next year. So roughly now around 17 months. After that, from July 1st, 2025 to June 30th, 2026, there's a cure period, which must occur before someone can seek a private right of action. That cure period is 16 days. So the way we're defining it is you have until the next period or 16 days, whichever is left. This provision will sunset on its own accord without any further action from City Council. And the Office of Labor Standards will provide a report to the City Council to inform City Council as to whether this provision should not sunset on that date and be extended. For paid sick leave components, a private right of action is available right away. It's available under the city's current paid sick leave ordinance, so that is not changing. It's available at the moment, and it will be available on July 1st once the new ordinance replaces the existing ordinance. I mentioned that there's a rural and outreach effort. So I'd like to start off with by saying that the record requirements under the ordinance that must be kept by employers only apply to covered employees whose regular work duties occur within the geographical boundaries of the city. So the city published proposed rules on December 20th of 2023. They can be viewed on the Office of Labor Standards website, chicago.gov/labor standards. There is a public comment period, which will conclude on Friday, February 16th of 2024. All comments will be reviewed individually and incorporated into the final version of the rules. It's the intent of the city to have finalized rules in place on April 1st of 2024. In addition to the proposed rules, The city has posted an FAQ document on the website. It's been posted since December 20th of 2023. The city held webinars on the new ordinance in December of last year. So December 14th in English and December 15th in Spanish. Just like today, we will host and record subject-specific webinars in the months of March, April, and May, leading up to the July 1st date. These webinars will be tailored to specific subsets of relevant stakeholders. So whether you're an advocate group, an auxiliary industry such as attorneys or payroll companies, employers themselves, and workers. And just like today's webinar, recordings will be available on the BACP YouTube page, which is youtube.com/Chicago BACP. Complaints and investigations. Complaints can be submitted via form, whether it's online or by mail, or by calling 311 or using the city's SHI 311 app. Additional resources are available on the Office of Labor Standards website. We would receive a complaint, conduct an intake or triage, review the complaint, contact the complainant. If necessary, issue a subpoena to obtain records from an employer, enter into settlement discussions, which might mean an administrative, a notice of administrative hearing violation, sending someone to the mayor's licensing commission, or filing a case in circuit court. And then on the screen, you can see the first page of the 2-page complaint form. I mentioned the OLS website. It's a valuable resource tool for employees and employers alike. Each ordinance under our jurisdiction has its own section or click box. Each subsection has information on the specific ordinance, any applicable rules pertaining to the ordinance, and FAQ documents. The information on the website is available in the top 5 languages spoken in the city. And again, that website is chicago.gov/labor standards. And this bottom box is the first alert that you'll see. So it contains all of the information that we've discussed today, the updated paid leave and paid sick and safe leave ordinance. There's a copy of the November 9th ordinance, the December 13th amendment, the frequently asked questions document, an informational flyer. So everything that you see on your screen in blue are active hyperlinks that'll lead you to a PDF for them. Beneath that paragraph are the proposed rules for paid leave and paid sick leave, and then updates for Chicago minimum wage and wage staff rules. They're a reminder that we will accept public comments until February 16th of 2024. And then there's information as to how you can submit a question or comment to inform our outreach and compliance effort. You can do so in writing to the address that's listed on the screen, via email at bacplaborstandards@cityofchicago.org, or bacpoutreach@cityofchicago.org. In the coming days, we'll be adding a third option. So we will have a Google form that you can enter comments and leave contact information in. If you don't want to send us an email or send something in writing, you can complete a quick survey. We hope to have that up before the end of the week. So that'll be a third option under which we are accepting questions or comments on the ordinance and the proposed rules. It could be you are in favor of it, against it, you have questions or concerns. There's some items missing from the FAQ that you would like to see added. You need further clarification on the proposed rules that we have posted. I will end my portion of the presentation by once again reminding everyone of youtube.com Chicago BACP /Chicago BACP. It contains recordings of upwards to 50 webinars that OLS has hosted throughout the years. Many webinars are available in Spanish along with their English version. And then on the screen right now, you can see the December 14th English version of the overview that was held last December. I will leave repost contact information. I'll leave it up for a couple of seconds. Here's our phone number. The emails are bacplaborstandards@cityofchicago.org or bacpoutreach@cityofchicago.org. And then here is our mailing address. So I will turn things over to Ms. Wright. So I will bring up her presentation.
Thank you so much, Miguel, and good evening, everyone. My name is Tamiya Wright. I am legal counsel for the Cook County Department of Human Rights and Ethics. And for the second part of this presentation, I'll just be giving you a brief overview, discussing a little bit of the mission of the Cook County Commission on Human Rights, and then also a little bit about the Cook County Paid Leave Ordinance.
And apologies, let me bring it back up. Okay, and I will move these screens once you let me know. So
okay. Thank you so much, Miguel.
You're welcome.
Okay. So just a brief overview of the mission of the Cook County Commission on Human Rights. It is twofold. First, our mission is to protect Cook County residents from discrimination in areas of housing, employment, public accommodation, access to county programs, facilities, and services. And then the second part of that is to make sure that those who work in Cook County or for the benefit of Cook County are appropriately paid for their labor and receive adequate benefits. Okay, next slide, please. Okay, and just a brief overview of the Cook County Paid Leave Ordinance. This ordinance went into effect on December 31st of 2023, and it means that employees who were currently employed as of that date, and then those who began employment as of January 1st of this year are covered by the Paid Leave Ordinance. And this applies to employees who work for an employer in Cook County and or an employer who has a place of business in Cook County. And I'll note that our ordinance does not cover the city of Chicago or municipalities that have chosen instead to comply with the Illinois Paid Leave for All Workers Act. So under our paid leave ordinance, employees earn 1 hour of paid leave for every 40 hours they work. This applies to full-time, part-time, temporary and seasonal employees. It also includes domestic workers. And I'll note that there are a few notable exceptions, such as independent contractors, and there may be further exceptions, and we have a full list of those in the language of the ordinance and as well on our website. So for full-time employees, an example, if you work 40 hours per week, those employees will accrue 40 hours per year. And part-time employees who work less than 40 hours a week would accrue less paid leave compared to full-time employees. So paid leave can be used for any reason, as I stated previously. Previously in our earned sick leave ordinance, leave could only be used for illness or doctor's appointments, but notably now under the paid leave ordinance, employees can use paid leave to attend a child's school event, for vacation, to take a mental health day, for any reason that employee chooses. Employers cannot require employees to provide documentation or proof of illness to use paid leave and cannot retaliate against employees for using paid leave. And I'll note for employers that employers may adopt policies that do establish parameters for use of paid leave. For example, notice requirements, and there are limited reasons that employers may deny paid leave for operational necessity. However, any such policy must be communicated to employees, applied equally to all employees, and conform with other applicable state and federal laws. And employees can choose whether or not they want to use paid leave prior to using any other type of paid leave. And that includes paid or unpaid leave provided under federal or state law. Next slide, please.
Before I switch to the next slide, I do want to apologize. The chat functionality is now fully operational if you guys want to add questions through chat.
Okay. Thank you, Miguel. And so just a note, once again, the paid leave ordinance applies to Cook County municipalities, except for Chicago, that have opted into our ordinance and not into the state of Illinois ordinance. This also applies to units of local government, park districts, and school districts. Next slide, please. Okay, and just to go over a few employee rights under the Cook County Paid Leave Ordinance. So, as stated earlier, this ordinance became effective December 31st of 2023. So if you were working for your employer when this law went into effect, then you would begin or be eligible for paid leave as of January 1st of this year. Employees hired after the ordinance effective date or December 31st of 2023 will become eligible for paid leave on their start date of employment. So for instance, an employee whose start date is February 1st of this year, that is their date of eligibility under our ordinance. And I will note that your employer may choose to allow you to accrue paid leave 1 hour for every 40 hours worked throughout the course of the year, or they have the option to front load the full amount of paid leave that they anticipate you will accrue at the beginning of the year or the beginning of your accrual period. So an example of this front loading, I'm sorry, Miguel, can you go back real quick? Thank you. Would be for someone who works a 40-hour week. If the employer decided to credit the 40 hours at the beginning of the year, they could front load the hours that way. And then I'll note too that the paid leave ordinance does not impact collective bargaining agreements that were in effect on or before December 31st of 2023. After that date, employers and employees may agree to waive the provisions of the paid leave ordinance, but only if those terms are set forth explicitly in clear and unambiguous terms in the agreement. Okay, next slide, please. Oh, and I should note one more thing as far as use. Current employees who are working for their employers as of the effective date of this ordinance are eligible to begin using paid leave 90 days from either the date of the ordinance or 90 days from their start date. So if you were currently employed with your employer as of December 31st, then you would be able to use paid leave around March 31st or April 1st of this year. Employees hired after that date can begin using paid leave 90 days after their start date. So for instance, in the previous example, if I start February 1st of this year, then I would be eligible to begin using paid leave around April 30th or May 1st. Okay, some employer responsibilities under the paid leave ordinance. The first thing is record keeping. So employers are required to maintain records of paid leave accrued and used for a period of no less than 3 years under the ordinance. And I will note here that if employers offer more than one category of leave, for instance, vacation, sick, or sick leave, in addition to paid leave, then they must keep track of the number of hours specifically of paid leave used in relation to those other types of leave. Increments for use. So employers cannot require employees who typically work more than 2 hours in a scheduled workday to use leave in increments of greater than 2 hours. So for instance, an employer could not require an employee to take 3 hours of paid leave at a time, or 4 hours of paid leave at a time, or to take half of a day. That would be a violation of our ordinance. And as far as carryover, generally, carryover of any accrued unused paid leave is allowed unless an employer front loads. In that instance, employers are not required to carry over unused paid leave, and can have a policy whereby employees are required to use front-loaded paid leave prior to the end of the year. Employers may also set limits on the use of carried over paid leave. For instance, an employer could specify that employees are not required to allow use of more than 40 hours in a 12-month period. So payout of paid leave is not required upon termination under the Cook County Paid Leave Ordinance unless it was credited to an employee's paid time off or vacation account. Okay, next slide, please. Okay. And to continue on some of the employer's responsibilities under the Paid Leave Ordinance, employers are also required to post notice of employee rights under the Paid Leave Ordinance. All of these notices should be posted in a conspicuous place at all work sites the employer has located within the geographic boundaries of Cook County. I will also note as well that employers are required to provide this notice at the beginning of employees' employment and prior to any changes to an employer's paid leave policy. A few more things to note as far as notice requirement. If an employer typically communicates its policies via email or electronic means, they must also provide the notice to the employees in this manner as well. And we have the notices in 7 different languages on our website that are available for employers to use. Okay. And a couple of things to note about the complaint process. So the complaint form for employees to use for violations of the Paid Leave Ordinance is available in 7 different languages. It is under the File a Complaint for Violation of the Paid Leave Ordinance page on our website. The complaint process is very similar to what it was under the Cook County Earned Sick Leave Ordinance. So employees have 3 years from the date of a violation to file a complaint with the commission. And if there are ongoing or repeated violations, then it would be 3 years from the date of the last violation. Some examples of violations include providing employees with fewer hours than what they should have received, failing to notify employees of their rights under the Paid Leave Ordinance, or failing to post the workplace notice in a conspicuous place at each facility where an employee works in the geographic boundaries of the county. In addition, requiring employees to provide documentation or any kind of certification prior to allowing them to use paid leave, and requiring that employees use paid leave in increments greater than 2 hours per day. Next slide, please. And this illustration here just sort of outlines a little bit of our complaint process. So typically, once a complaint is filed, we serve the respondent, in this instance, the employer. They are given an opportunity to respond and submit written arguments in response to the complaint. And then usually at that point, our investigators may recommend mediation or settlement of the matter if that's a possibility, or may proceed with investigation. If the investigators determine that there may be evidence of a violation, then the matter could either be referred to administrative hearing to be decided, or If the investigators find that there is a lack of substantial evidence, then the case may be dismissed. Okay, next slide, please. So enforcement and penalties under the paid leave ordinance. I will note that we will begin enforcing this ordinance as of February 1st of this year. And that is the date that we will begin to receive complaints as well. If an employer is found in violation of the paid leave ordinance, then they may be liable for any of the following, and that can include damages for underpayment, compensatory damages, and fines that range anywhere between $500 to $1,000. And specifically for notice violations, it would be $500 for the first violation and $1,000 for each violation thereafter. And then I'll note as well, similar to the city, the paid leave ordinance allows for individuals to file a private right of action if they so choose, but one difference is that we do not have a cure period. So next slide, please. And then I'll just be touching on a few additional jurisdictional differences between the county's ordinance and Chicago's ordinance. Okay. So there are a few similarities and a few differences between the city and Cook County. Some similarities are that both ordinances offer paid leave that can be used for any reason and allow for leave to be front-loaded or accrued and provide for the option for employees of an individual right of action. Some differences to note are that the city of Chicago provides for paid leave and paid sick leave, whereas our ordinance specifies paid leave to be accrued 1 hour for every 40 hours worked. And then next, the city of Chicago, their accrual rate is 1 hour for every 35 hours worked. And the city requires payout of paid leave based on an employer's size, whereas we don't make those distinctions. And then additionally, as I stated earlier, there's no cure period in the Cook County paid leave ordinance. And then I believe the city of Chicago limits employers' ability to restrict paid leave to 4-hour increments, whereas our ordinance, employees cannot restrict paid leave to increments greater than 2 hours. Okay, thank you, Miguel. Next slide. Okay, so this is just a Venn diagram that we've included. It just notes the similarities and differences between the Illinois Paid Leave for All Workers Act, the Cook County Paid Leave Ordinance, and then Chicago's Paid Leave and Paid Sick and Safe Leave Ordinance. This is included on our website. I won't go over it now, but just wanted to let you all know. Well, I don't believe it is included on our website, but it may be a resource that we do add later on, but just wanted to point that out. Thank you, Miguel. All right, some additional materials that are on our website and I wanted to note for reference are the paid leave ordinance and regulations and file a complaint for violation of paid leave ordinance pages. Some additional resources on these 2 pages on our website include our paid leave complaint form, as I stated, that's available in 7 different languages. In addition to the workplace notices that are required, we have paid leave FAQs and a jurisdictional comparison chart, which is a helpful resource to refer to, and similar to the Venn diagram that you saw on the previous slide, outlines the differences between the state, city, and county ordinances and or acts. So our paid leave procedure rules are in progress. We anticipate that these rules will be finalized. Ignore the January 18th date. We anticipate that they will be finalized in early March of this year. Okay, next slide, please. So if you have additional questions, please feel free to reach out to us. Of course, as I stated, our procedural rules are still in development, but in the meantime, we understand that there may be additional questions, so feel free to give us a call at 312-603-1100. Our address is 69 West Washington, Suite 1130, Chicago, Illinois, or you can email us at human.rights@cookcountyil.gov. The QR code included on this slide also has a link to our website where you can access all of the information that was referenced in the previous slide, as well as the jurisdictional comparisons chart. So we hope that you reach out to us and let us know your questions and concerns. And we thank you for attending this training. Miguel, I'll turn it back over to you.
Thank you. I'll leave the county's contact information up for a few minutes. I'll start reading through the Q&A and questions that have been asked in the chat box. In about 5 minutes, I'll throw up the city's contact information. So I'll keep alternating between the two in case people have questions. So I'll start with the Q&A questions. Please note, if we do not provide you with an answer today, and we have your contact information from when you registered for the webinar, we will follow up with you this week and provide answers to you. So the first question's easy. Can we get a recording of this presentation? So there will be a recording on the city's BACP YouTube page. We anticipate that it will go up tomorrow. So the next question is the small or large employer numbers for the city of Chicago only or company-wide or country? So that's a question directed at me. That number of employees for an employer are company-wide, so not just working in the city. So if you happen to work for an employer who has 100 or one more national or global employees, then you would be considered a large employer. The next set of questions are, how does PTO apply to gig employees versus regularly scheduled employees? If you can provide a little more clarity, if you mean like an independent contractor as a gig worker, you would not be covered under the city's ordinance unless you are a domestic worker.
And I'll note too, that's the same for the Cook County paid leave ordinance. Independent contractors are not covered unless they are domestic workers.
And then the second question that this individual asked was how to determine number of employees for size of a company. It would be, so it's not an average for the year or full-time or part-time. It essentially would be when someone files a complaint. So most companies are not oscillating between sizes, like they'll stick between a specific size. But that is how we determine number of employees. Do the postings need to be posted even if the company offers more than the required 40 hours? On the city side, that is a yes. The poster or informing people of their rights needs to be posted even if you are exceeding the limits set by the city ordinance. And now let Ms. Wright answer for the county.
Yes, thank you, Miguel. That is true as well for the county. So regardless, employers are required to post the notice.
And then I believe this was a follow-up on the same question. They were providing an example where there are 3 weeks of time off that can be used for any reason. So you would still be required to post either the county or the city poster informing people of their rights. Public comments can be anonymous. That was a question that was asked. You can send something in writing, the Google form or Microsoft Teams form that will be on there. It will not be required that you provide your first, last name, phone number, or email address to leave a comment. We welcome any public comments. There's a question asking if you are in the city of Chicago, if you just follow the cities and not the counties. That is correct. If your employees conduct their work within the geographic boundaries of the city, you would have to follow the city ordinance. Ms. Wright, this question's for you. I think I know the answer, but I'll let you answer. Does the Cook County paid leave get added, or is it an addition to the Illinois Paid Leave for All Act?
So the Illinois Paid Leave for All Workers Act applies to workers in Illinois. Our paid leave ordinance applies to employees that perform work in Cook County for an employer located in Cook County. So they're very similar to each other, but those who are in Cook County would be under our ordinance unless they choose to instead abide by the state's Paid Leave for All Workers Act, if that makes sense.
This is a question in the similar vein. So with 3 sets of rules, the leave for all workers, state statute, Cook County ordinance, or city of Chicago, which supersedes each other, on which should we defer to if our team is all in the city of Chicago. So if all of your employees work within the geographic boundaries of the city, then you would have to only follow the city of Chicago paid leave and paid sick and safe leave ordinance. So regarding the Cook County leave ordinance, Tamiya stated a full-time employee works 40 hours, they will earn 40 hours for the year. I want to clarify, if a full-time employee works 40 hours a week for 52 weeks, would they earn 52 hours?
Sorry, can you repeat that question?
You stated that a full-time employee who works 40 hours a week will earn 40 hours for the year, and they want a clarification that if they work 40 hours a week for 52 weeks, would they be earning 52 hours, or would they be capped at 40 hours?
I just want to make clear that under our ordinance, it's 1 hour for every 40 hours worked. So there may be a likelihood, for instance, for part-time employees that work 20 hours per week, and within that, that's consistently their schedule for the entire year, they would earn 20 hours. For those, we just use the example who have worked, or their typical work schedule is 40 hours per week. They're still earning 1 hour for every 40 hours worked. So I think you just might want to keep that in mind. We'll be issuing additional guidance on accrual in our procedural rules, but for now, it's just 1 hour per every 40 hours worked is the accrual rate.
Then, Tamiya, someone wants to know if you will be keeping a list of municipalities that have opted out of the Cook County paid leave ordinance.
We will not be keeping a list of municipalities. I would recommend that, I'm sorry, 1 second. We intend to make a list available. It will be updated as further information becomes available. So I'll say that for right now. Right now, we don't have anything posted on our website, but we will be developing a list of those municipalities as we're notified.
The next question is for me. We have a PTO plan that exceeds the amount of paid leave and paid sick. Do we need to add another plan to include sick for employees working in Chicago only? My initial response is no. So if you have a paid time off plan where people are given time that can be used for any reason, at least in the city. So if you have a PTO plan that gives more than 80 hours a year, and then that time can be used for any purpose, including paid sick leave, you do not need to add additional time. So it's going to depend on the amount of time that's granted by PTO. For specific questions, if you guys have a specific policy in place already and you want to get into semantics, we would prefer that you email either the city or the county, and we can provide a more appropriate response on a one-on-one basis rather than in an open forum. I'm scrolling through will Cook County be specifying a threshold amount of time worked in the county for employees to be considered covered employees? For example, Chicago's ordinance specifies a threshold of 80 hours worked in any 120-day period.
So to answer that question, that will be covered in the procedural rules. Currently, a draft is available online on our website, but that will be finalized and it's currently going through the process. So we anticipate that that will be finalized early in March.
There's a question here that's not related to the paid leave that we're discussing today, but with regards to the city, so someone wants to know how can you check to see if your employer has a business license? With the city, it's there's an open data set, so you can just Google like City of Chicago business license lookup, and it'll take you to a city website that'll provide you with a list of all active licenses that you can search by zip code, by address, by DBA, or by legal name. There was a clarification on the gig ad or gig question that was answered around 15 minutes ago. So the clarification is that they make up their own shifts or make up their own schedule. They're part-time workers, but they get a W-2. They would be considered a covered employee for these purposes. So for the city, as long as they're working 80 hours in any 120-day period, they would qualify for the paid leave and paid sick leave provisions of the city ordinance.
And then in terms of the county, sorry to provide the general answer, but we are still working to provide further guidance on those matters in our procedural rules.
There's a question that's somewhat specific. So our headquarter office is in Chicago, but one of our locations is outside of Chicago. Does that one location follow the Cook County ordinance and the rest follow Chicago's? My initial answer is yes. All of your Chicago locations would have to follow Chicago's ordinance. And then Tamiya can correct me if I'm wrong. If that Cook County area has not opted out of the Cook County ordinance, they would have to follow it for the one that's not in Chicago.
That's correct.
There's a question about remote work. So remote employees who are working from their home in Chicago. So let's say the company is based in Dallas and you happen to work from home, you would be covered by the Chicago ordinance. So those were the Q&A questions, and I'll take a quick look through the chat functions. for those questions in there. Some of them are similar, some we've answered already. Tamiya, someone wants to know if workers can carry over their Cook County PTO from 2023 to 2024.
That is a good question. So paid leave went into effect this year. So leave accrued in 2023, previously earned sick leave, and our earned sick leave ordinance applied prior to the passage of this ordinance. Employers are not required to carry over sick leave or convert prior sick leave under the sick leave ordinance into paid leave.
There's a question seeking clarity on the minimum usage for paid leave and paid sick leave. So for paid sick leave in the city, there's a minimum increment usage of 2 hours. So that means if an employee can use their time in chunks as little as 2 hours. So for example, if you're taking your child to a dentist appointment, your employer cannot ask you or demand that you use a full day or even half a day. If you work till 5 and you want to leave at 3 to make it to a 4 o'clock dentist appointment, you would be able to use your paid sick leave in chunks of time as little as 2 hours. For the paid leave component, it is 4 hours or half a day. So you're able to, if you work an 8-hour shift, for example, you can take off half a day for paid leave purposes, or larger. So that chunk of time cannot be smaller than 4 hours. And Ms. Wright, it's 2 hours for the paid leave for the county, correct?
That is correct. So we're somewhat similar to the city's requirements for paid sick leave. Employers cannot require an employee under our ordinance to take paid leave in increments greater than 2 hours. So as Miguel stated, the example he gave, an employer could not require an employee to take half a day or even a full day. That employee could say, I only want to take 2 hours. An employer can't require more than that at a time.
Someone wants a quick explanation on front loading. So that's just how your employer provides you with your paid time off. So for example, you can get all of your vacation at the beginning of the year. So let's use January 1st as a day. So you're going to get 10 days of PTO. Come January 1st, you have 10 days worth of time in your bank that you can start using immediately, as opposed to accruing where you're earning every paycheck or every month. So you can earn an hour for every 40 or 35 hours worked. Now you're going to be earning like 4 hours a month. So you're slowly building up your bank of time that you're able to use. Some employers choose to just give that to their employees upfront. So that is what we mean by front loading. So I own a small business in Chicago. Our work typically runs from March to December. Employees currently receive 1 week of paid vacation. Is my company subject to the requirements of the ordinance? You are subject to it. It would be at that rate. So if they do not earn, if they're not working full-time from March to December in those 9 months, it might happen to be that they don't earn their full 40 hours of either paid leave or paid sick leave. As long as you're granting them 1 hour for every 35 hours worked, 1 hour of paid leave and 1 hour of paid sick leave, you'd be in compliance. This would not be in addition to the time that you already provide. So the 1 week of paid vacation that they get could be paid leave, and then you would just be providing paid sick leave on top of that, which you should be doing already under the current city ordinance. there's a question asking where they can find the full language of the City of Chicago ordinance. I'll go back to the city website. So I know this was probably asked before I got to the screen, but chicago.gov /labor standards, at the very top of the page. You can see the arrow cursor hovering now. That blue text or link, it's a hyperlink that'll give or direct you to a PDF of the amendment on December 13th and the November 9th ordinance. So you can go to our website for direct, quick links to the ordinances. I will put the county contact information back. Tamiya, someone wants to know, you mentioned credited to paid leave or vacation, if you can expand on that.
So any unused accrued time that is classified as paid time off, meaning that it's available to be used for any reason, or vacation time, PTO, it's another common term that's used for it, should be paid out upon separation from employment. I hope that answers their question. It's somewhat consistent with the Illinois Wage Payment and Collection Act because vacation, certain things like that, like vacation, are required to be paid out, whereas sick time is not required to be paid out. But I will note too, please, if you do have additional questions, feel free to email us at the email address listed, human.rights@cookcountyil.gov, and we can answer certainly additional questions on that. And then, as I stated earlier, we'll be providing additional guidance on those issues too in our procedural rules.
Someone wants to know if they offer employees sick and vacation time. Do they meet the requirement, or do they need to provide paid time off in addition? No, if you're providing time in excess of what's being required, that vacation time can be considered paid leave, as long as it can be used in the 4-hour increments, and for any reason, you do not need to provide additional time. Can an employer simply pay their PTO at the end of the year if the employee doesn't request any PTO? Or does the employee carry over their PTO to the following year? The carryover component for the city, there is a limit of 2 days of time that can be carried over. So in the city scenario, you would be able to pay it out. We're not establishing or dictating what your policy should be. And I'll let Ms. Wright answer for the carryover of paid leave for the county.
Thank you, Miguel. So generally, we do require carryover of any unused and accrued paid leave. And I hate to be vague once again, but we're still working on developing our procedural rules, and we'll be touching on those specific issues more so once the procedural rules are finalized. So in the meantime, I know it's not the best answer I can give right now, but please email us if you have a specific inquiry, and we'll be able to address those types of specific questions on carryover or provide additional guidance in the procedural rules.
For the individual that wanted a copy of the city's PowerPoint presentation, if you send an email to BACP Labor Standards at cityofchicago.org, we will provide you with a PDF of the PowerPoint presentation used this evening.
And you can email us as well if you'd like to receive a copy of our PowerPoint. I will note a few things that I forgot to mention earlier, just for individuals who decide to file a complaint with us. Filing a complaint is free. You do not have to have an attorney to file a complaint with the commission. So I just wanted to note those things for any employees.
And it is the same thing for the city. You do not need to pay anything. And then we are here to assist you. Someone asked for a link to the YouTube page. It should be the last message you guys saw in the chat. Or you see in the chat now. Let me scroll back up. And then Tamiya, for clarity purposes, you said that an employer can cap available hours to use at 40 hours per year, correct? So for carryover, or they can set limits as to how much paid leave someone's able to use?
No. Sorry, could you give me one moment, Miguel? Sorry.
Yes.
Okay, I'm sorry, I apologize. So that will be addressed in our procedural rules. Yeah, I'll leave it at that right now because we're still ironing out some of those issues.
Someone's asking a similar question to there's 52 weeks in a year. So the rate that you're earning at, whether it's 1 hour for every 35 hours worked or 1 hour for every 40 hours worked, you can set a cap. So once you grant somebody 40 hours of paid leave or paid sick leave, you do not need to provide any additional time beyond that. So for the city, once they hit that cap, if that's what your policy is, then that's what you're providing them. And again, nothing's preventing you from exceeding that rate. You can provide people with 12 days of paid leave and 12 days of sick leave if you want to. The ordinance sets limits. So once you meet those limits, you are not obligated to provide additional time off. Someone's requesting to show the Venn diagram with the various leave ordinances overlaps. I'll scroll back to that page. I'll leave it up for a little bit. And then the cross-jurisdictional chart that she mentioned that is available on the county website. The city will also make available on our website. It's something that we work together with the Illinois Department of Labor to show the differences between the three. So the state, the county, and the city. That will also be you'll be able to find it on the city website. There's a question saying an employee who has earned 40 hours can theoretically use 2 hours a day to get off early 20 days in a row. Are there any limitations? Again, you're able to establish your own paid leave policies as long as you're being upfront with an employee and that they're aware of them. You're able to maintain fully or full operational capabilities for your business. There's a question about what rate a tipped worker would be paid. So in the city, it would be the highest of whatever their base salary is or the city's minimum wage. So for example, if you're paying a tipped worker $9.48 an hour and you're utilizing the tipped wage credit, that paid leave or paid sick leave would have to be paid at the city's full minimum wage which would be $15.80. So they are not paid the tipped minimum wage, it would be the full minimum wage.
And then for the county, the rate of pay for paid leave would be the rate for non-tipped minimum wage.
Does paid holiday time count towards the 35 and 40 hours worked? No, it does not. It would be actual time that they work. So if someone has MLK Day was just last week, that paid holiday would not count as part of the 35 or 40 hours worked in order to earn an hour of paid leave.
And that is true for the county as well.
The Cook County ordinance went into effect on December 31st for the individual who asked. I am typing in the email address for people who want a copy of the PowerPoint presentation. The YouTube link will be, it's up ahead. I can copy and post it back. And again, the actual recording will be up tomorrow. No, if all of your questions have been answered, you do not need to stay around for the rest of the Q&A. There are some questions that you guys have not asked, which are available on either the city's FAQ or the county's FAQ, and you can go to our respective websites to obtain FAQ documents that exist. And then I will switch to the city's PowerPoint. So here's contact information. And then there's a YouTube page for people who are not, can't see it. So it's youtube.com/Chicago BACP. You should see it in the chat function. So we are nearing the end of the allotted time. If there are any questions that were not answered, or if you want one-on-one consultations, feel free to send an email to either the city's Office of Labor Standards or to the county, and we'll be able to provide additional information. If you're unsure as to who your question should be asked, feel free to send it to either or. We are in constant communication with each other, and we can forward your question to the appropriate agency if you happen to send it to the incorrect one. We hope to have a similar version to this webinar, joint webinar in the future. And again, I want to remind everyone that the city, with regards to the city's upcoming July 1st changes, we will have a more rigorous outreach effort in March, April, and May. But feel free to reach out to either agency if you guys have any questions. Thank you for your time this evening, and I will give you guys back 10 minutes of your evening. Thank you.
Yes, thank you so much, everyone. We appreciate it. And thank you, Miguel, for hosting this.
Thank you.
Mhm.